the discussion about how do we protect our estate for the purposes of income taxes, but now we're going to talk about it as it's passing to our children or our grandchildren, or if you don't have children, how is it going to these other beneficiaries that we'll call non-spouse beneficiaries? So the statistics say that between 50 to 75% of non-spouse beneficiaries, when they receive the benefit of an IRA or 401k at someone's death, they are taking the lump sum. So you leave them $100,000, they're taking the $100,000. Maybe they're just having the tax withheld on the front end, maybe they're not, but they are taking the lump sum. Currently, there is a more tax efficient option available to them. It is typically called a beneficiary IRA or a stretch out IRA, where the beneficiary can take the remainder of that IRA that they received over their remaining lifetime. There's an IRS table that says, hey, you got to take this percentage each year. And as you get older, the percentage goes up and up and up. And if you live to the end of the table, you will have liquidated the entire account. So a lot of people have become much more educated upon this option. It's been around since about 2001. I will say that this may go away. There has already been a resolution passed in the House of Representatives to get rid of that and make it a maximum 10-year payout rather than over a lifetime. I won't get into all the policy reasons, but that has been passed in the House. It has not gone through the Senate at this point. So the point here with your IRAs, though, when you leave it to your kids or your non-spouse beneficiaries, is it now becomes incumbent upon them to choose the best tax option if they seek advice. So many people don't go out and seek advice because they're already going to pay off their mortgage or buy that new car, or they want the money to send their kids to college, or whatever their reasons are, they're going to take that money. That's why the statistics say 50 to 75% of these beneficiaries take the lump sum. So, for example, I had recently a client that I spoke to where they had taken about $100,000 from a mother's estate in the form of an IRA. And later they read about the scenario where you could stretch it out, and they asked questions about that. But in talking with them again, they were saying, well, even though we had to pay some tax on that, now we have more options because now it's moved over to the non-IRA side. Now I can invest it however I want. Now if I want to use it, I don't have to worry about tax consequences for it. I got that all over with on the front end. They can invest it however they want, use it however they want. Oh, by the way, when they leave it to their family, their children, guess what they don't have to do? They don't have to pay the taxes on it because the stretch out IRA only goes one generation. So if my parents leave me an IRA and I stretch it out over my lifetime, that beneficiary IRA, and something was to happen to me and I passed away, that stretch out does not continue for my children. It's a one generation thing. So there might be some good reasons to take the lump sum. Even though there are more tax efficient options, you can see how someone could reason of why they should take it all, because it does simplify it. See, if you have IRA money, everybody wants it to be the KISS principle, right? Keep it simple, stupid. Well, the KISS principle with IRAs goes away because now they have to make these tax choices. Maybe they understand it, maybe they don't. Maybe you've got kids in different tax brackets. See, most of us want to leave it to them equally, right? So if you've got two children and you're leaving it to them and they're in two different tax brackets, one kid gets more just because of the tax brackets. Or what if your children are in a higher tax bracket than you? Now all of a sudden Uncle Sam gets more. Or what happens if the tax rates go up? If they go up at some point in the future and your kids even at the same tax level as you would be paying more than you could have today, we just lost the game to the IRAs. And if you want to try to protect it from your kids' divorces, their spendthrift ways, their creditors, their premature death, Who are they likely to leave it to if they die? Well, if they're married, it's typically going to be their spouse. Well, how do you feel about their spouse having your IRA to now go find a replacement to your child? And it may or may not pass down to your grandchildren if you have them. So my soapbox here yet again is it sometimes makes sense to pay the taxes now. Why? Well, if you pay the taxes now, number one, you can control how much you take out and how much percentage-wise goes to Uncle Sam. And you now have the benefit of moving it over to the non-IRA or non-qualified side of things, and you can invest it however you see fit. And you can use it whenever you want. And when you leave it to your children, now they don't have to think about, well, what are the tax consequences of me taking this money? So even if you want to just leave it to them directly, you're not trying to protect it for them in any form or fashion from their creditors, their bankruptcies, their divorces, their premature death. You're not worried about that. If you leave them non-IRA money, they have more ability to do whatever they want sooner with it. And they don't have to think about the tax consequences coming with it. Now, if you are wanting to try to protect this, I'm not saying in any part of this show that you should go and take all of it, right? Don't go running out and liquidate your whole IRA. That is probably not a real tax efficient way of doing it. Always consult with your tax advisor. But if you have qualified money or IRA type money remaining at your death and you're wanting to try to protect from all of these things for your children or your non-spouse beneficiary, and you're going to leave it through your will or you're going to leave it through your trust, you need to ensure that you have the right language inside of your trust. Because if the language isn't there, the options may not be available to be as tax efficient for your beneficiaries. And in particular, if at any point you have a beneficiary, say even remote contingent, meaning your whole family has to die, if that remote contingent beneficiary is potentially a nonprofit or a charity, that could blow up the ability to be tax efficient with this money if you do not have the correct language inside of your estate plan. So if you have IRA money, which most of us do, you just have to think more about it. You have to think about all of the risks. You have to think about the tax risk to you, the tax risk to your beneficiary, the risk of the beneficiary losing it to their spendthrift ways, their creditors, their bankruptcies. Oh, by the way, in 2014, the Supreme Court changed the rules and the law pertaining to protections of IRA money that passes to your children. If your children receive it, they no longer have the same protections you have over your current retirement monies from your bankruptcies and your creditors. They have lost that because of that 2014 opinion. So you have to think harder, folks. This IRA money, I know that you did a great job of saving it. We've saved it into all of these different spots. And we've watched it grow tax deferred, and there are statistics that would show that tax deferred money grows faster because it compounds on itself. And I don't disagree with that. But when we start to get to the distribution phase of your life, sometimes we have to look a little bit harder. We have to look under the rock, I like to call it, and say, should I pay some tax now? Should I take out $10,000 this year above and beyond my RMD so that I can start moving it into a tax unqualified account, a non-qualified account, so that when I pass away, guess what? Now I can protect it for my kids. We had a client a few years back. Their beneficiary is easily swayed by others, not good at handling money themselves, not necessarily because of any major disabilities, just somebody that's easily preyed upon, rather naive. Well, this client has a significant portion of money saved into IRA type money. Well, even if we choose the stretch out option over that beneficiary's lifetime, those distributions could be rather large. When I say rather large, in the $50,000+ range per year, even with that required distribution only. Well, they're worried about this individual, this beneficiary, not using the money wisely, and they're not sure that he could handle it himself. So now we're talking about setting up a trust, and we put it into the trust at their deaths. But now we've got to pay out potentially a big chunk of money as this beneficiary ages to that beneficiary, and we wanted to try to figure out a way to restrict how much that would be so that we don't have to give other monies. Maybe we're only paying out of the IRA. So you got to think about this. You got to take a look at your beneficiaries. You got to take a look at what portion of your estate is in this retirement money. Should I be doing things now to protect it from the tax risk for not only me, but for your children? Because if your children are in a higher tax bracket than you and you leave it to them, even if you leave it through fancy things like wills and trusts, there may be more taxation on it. And or they may not look into the options available to them. They may just take it. So we've got to be cognizant, folks, about how do we protect it for even our children. And sometimes the best way to protect it may be to take some of it now so you can move it into different categories. Or even what if you put it into a Roth IRA? Now, I'm not an investment professional, and I will never profess myself to be, but my job is to help you try to protect your estate. And part of your protecting your estate is protecting it from tax risk. And most of us don't have an estate tax problem, but we've got an income tax to our beneficiary problem. And if you are concerned about trying to protect that beneficiary from not just the income tax problem, but from other issues that might happen in their lives after you passed away, or even before, or just after you've done your estate plan, we have to take an open look at this. You got to talk with your tax person, you got to talk with your financial advisor, and you got to talk with your estate planning attorney. We need to be all working together to achieve the end result. Now, I know some of you are probably hearing me say this and you're saying, I could care less if my kids take every last dime, if they lose more to Uncle Sam, whatever, I'm dead anyway. And I don't say that that's not right thinking, because everybody has their own thoughts and beliefs about this stuff. But my job, again, is to help your family be protected. And one of the ways that we can protect your family is from income tax risk. Income tax risk at your death for your assets that pass to your beneficiaries. So we might want to take a hard look at things to protect. Is this the KISS principle? No. Can it work? Yes. Can it protect your estate from tax risk? Yes. But you got to start now, folks. You can't wait. You can't just say, well, they'll figure it out. Well, they may be figuring it out without the advice of any professionals, with the higher tax brackets, with the inability to stretch it out the way we can right now. They may not have the same options, so maybe it takes looking at it not just now, but looking at it as we move on into the future. Let's look at it every 5 years or so. What's changed? What hasn't changed? How much do we have there? Has it continued to grow? Are we taking it out now? What's going on for us? So as we head into the break here, I want to remind everybody